Distinguished Chief Guest, Sri P.H. Kurian, Advocate Nandakumar M.R., Secretary of the Kerala High Court Advocates Association, Advocate Johnson Robus, former President of the Society for Construction Law, Advocate Jasmine, Adv.Ajit, distinguished participants who represent the vendors, the societies, home apartment owners, advocates, SCL executive members, SCL members, ladies and gentlemen. Advocate Jasmine has dealt briefly with the Society for Construction Law. The Society for Construction Law was established in 1983 in the United Kingdom, which is the SCL UK. The Society for Construction Law India was established in 2016 and it is based in Delhi. The Society for Construction Law Kerala is a chapter under the Society for Construction Law India. The members of SCL come from various branches. There are advocates, there are engineers, surveyors, architects, developers, arbitrators, and different experts. So, if any of the members, the distinguished guests present here today, if you are one of the professionals from any of these fields and wish to be a member of the Society for Construction Law Kerala, we have activities which are mostly educational and professional in nature. We have talks, we have seminars, we have discussion on emerging topics such as this on different days. So you may get in touch with us for details about membership to the Society for Construction Law. The aim of the Society for Construction Law is to advance the understanding and practice of construction law through education, research, and professional development. Presently, I am extremely happy that we are all extremely fortunate that we have a very active real estate sector. And as per the RERA Act of 2016, there is an authority now that regulates and governs the sector of real estate. As Sri P.H. Kurian debits office as the first chairman of the Kerala Authority, I see from the website of RERA that 1,393 projects are registered under the RERA. There are 569 registered promoters under the RERA Kerala, and nearly 2,000 complaints have been filed before the authority, which are now either under consideration or which have been resolved. I wish to congratulate Sri Kurian for laying a very strong foundation for the regulatory authority of Kerala. Very recently, in December 2024, Advocate Jasmine just dealt with our High Court, the Kerala High Court, in a case titled Apartment Owners Apex Association Kerala versus State of Kerala. The High Court considered the interplay between the RERA Act 2016, the Kerala Real Estate Rules 2018, and the Apartment Ownership Act of 1983. The Honorable Chief Justice, in his judgment, examined the sale deed that has to be entered between the promoter and the apartment purchaser. Clause 20 of Annexure A of the RERA Rules of 2018 is the format for the sale deed. And in that format, it is mentioned that the promoter has assured the allottees that the project in its entirety is in accordance with the provisions of the Kerala Apartment Owners Act 1983. However, the petitioner in this case argued that this is not being incorporated by the promoters in their sale deed to the allottees. The Honorable High Court held that this is a statutory requirement now. Clause 20 is a clause which is a statutory requirement. Therefore, all promoters in their sale deed have to incorporate that the sale and this project complies with all requirements of the Apartment Ownership Act 1983. And the Honorable High Court also directed that this has to be made mandatory by the state government and has given directions to the Housing Secretary of the state. And this has to be incorporated and made mandatory within 3 weeks of the judgment. In that context, our seminar today, our discussion today assumes great relevance as far as the incorporation of that Section 20 is concerned. For this development, I take the opportunity to pay tribute to our former president, Mr. Johnson Gomez, who argued this case before the Chief Justice. And he also got a favorable order in a similar case argued before the single bench. And Society for Construction Law was very much part of the litigation, which was led by Mr. Johnson Gomez. The apartment owners of Kerala have not adopted the Apartment Ownership Act 1983, despite it having come as way back as 1983. There is a question as to why this was not adopted. The Travancore Cochin Literary, Scientific and Charitable Societies Registration Act 1955 is used for the purpose of governing common areas and registering of societies and apartment ownership. The purpose of the Travancore Cochin Act is entirely different. It is member focused, whereas the Apartment Ownership Act is apartment focused and deals with all aspects of peace in the high rises, which is the topic for today's discussion. Our society, the Society for Construction Law, is registered under the Travancore Cochin Act, and all apartments also are registered under the Travancore Cochin Act. The purpose is entirely different. When we have an Apartment Ownership Act solely dealing with the topic of apartment ownership and governance of common areas, there is no reason why we should refer to the Travancore Cochin Societies Act or Registration Act, Charitable Societies Registration Act. On this occasion, let me welcome our Secretary personally for being here. Thank you, sir. And the purpose of today's meeting is to deliberate upon the Apartment Ownership Act, especially in light of the High Court directive. There are, of course, issues with the Act. We need to address those issues. We need to examine how to resolve it. At the end of the meeting, I am sure that there will be positive light. We'll have some positive points on how to make the Apartment Ownership Act truly useful and practical for the governance of our apartments. Thank you very much.